So John, thanks for the introduction and thanks for hanging in with me. I hope you guys ate a bunch of sugar. There was certainly plenty of it. I'm supposed to endorse the candied bacon. I can't eat it myself, but it's supposedly fantastic. So it looks like just regular bacon, but I think it's literally coated in sugar. It's supposed to be amazing. It's one of their specialties here. Don't leave in the middle of my presentation. Wait until the next break, and then you can have some of that. So as John mentioned, I'm a former federal prosecutor. I'm also a former state prosecutor. And I came to private practice at Gentry Law. And what I do most of the time is white collar compliance. Sometimes that looks like exactly what you would expect. I represent somebody who's charged in court as their defense attorney when we're looking at white collar fraud, regulatory enforcement issues. But what I also do at the firm, and the reason why I'm here in front of you today, it's not because John called and said, we have a room full of people and they look like maybe they could get federally indicted one day. They should probably meet you. That's not why I'm here. A huge part of what I do is actually helping all kinds of different businesses, organizations, and higher education institutions help with their compliance side of things, or do large scale investigations for them, or help advise them on smaller scale investigations. And that is because I have a much larger role in that than somebody in my position may have had 5 or 10 years ago, especially as it comes to higher educational institutions, because there's a lot more federal and state regulatory enforcement actions happening at higher education institutions. And so you've got both the Virginia Attorney General's office, the Federal Department of Education, IRS, FBI, all kinds of different agencies are starting to look at the activities of higher education institutions. I am sure you have already heard of some of the cases I'm going to talk about today, but really what I'm talking about mostly is going to be the compliance side of that and what that looks like for you. I'm not going to have to spend too much time telling all of you all of your compliance obligations. You're well aware of what they are, but I am going to talk to you about how do you balance the risks and the costs and the reputations of the university or the college or the institution you're working with when you're going into compliance and investigations. And a lot has changed in the last couple of years, and so I want to talk about that. So before we get started, I do have to plug my firm. I do work with Todd Leeson and some of the other people in our employment group quite a bit. They do a lot of work with higher education institutions, and I'm usually partnering with our employment lawyers when we have an organization that is going through some sort of compliance or needs some sort of investigation assistance. But I also have a whole bunch of talented partners that are subject matter experts in all of the places that are listed on the screen, so that if you do have that sort of compliance issue, I'm never going to stand up in front of you and tell you that I know everything there is to know about construction or zoning or intellectual property, but I have a partner who does, and that's who I call. So as we start to talk about some of these issues, just know that that's, we take a sort of partner approach, and that's what I'm going to be talking to you about today, about what you need to do inside your institutions. So this is your first poll. Now, I know that other people have told you it's optional, but again, lawyer, former federal prosecutor, I'm going to be a little bossier about it. I want you to take it because this is going to help educate me about providing you information that's most helpful to you. So the first poll, I want you to tell me what your area of responsibility is. What do I have to do? I have to do one more click. There we go. Okay, now we're learning. I'll hit the gavel when we're done voting. I'm just kidding. So your area of responsibility, and I like all of the above, the multiple hats, which is really interesting. Okay, so most of you do finance or tax. That's going to be your compliance, which is great. It's going to be a lot of what we're talking about. And then the sum, all of the above. And then some of you do none of the above. This will be educational for you today. All right. Okay, so how many years of experience in higher education? That jumped really fast. Look at all the super experienced people in the room. That's amazing. So more than 3/4 of you have a significant amount of experience working in the higher education field. And so you're probably the people who know what this used to look like for you and what enforcement used to look like, which certainly there was, but the areas of enforcement are changing radically for higher educational institutions. You're going to be coming in contact with agencies that you did not think you would come in contact with before. That's actually very helpful. Okay, and then the last one, this kind of cues this up. I don't mean to spoil it for you, but we're going to take this one at the end too, and see whether you have any different answers. So this is your largest area of concern for compliance in your institution. What is the thing that keeps you up the most at night, the thing you have to spend the most time on, the thing you feel is the most complicated? Not surprisingly, because we have so many finance people in the office, you are concerned with finance compliance, which is great. Notice I said 501c3 because that is a huge, that's a tax classification, but it's actually a huge area of compliance that does not really have to do so much with strict finance. And we're going to talk a lot about that today. That is an increasing area of interest both for the FBI and the IRS. Okay. Conflicts of interest and conflicts of commitment. Interestingly, very few of you put that as the primary area of concern and compliance for you. But if you're worried about 501c3 status, this should be one of your #1 areas of concern. Conflicts of interest and conflicts of commitment are probably the biggest risk to your 501c3 status. We'll talk about that in a second. Okay. Well, that was really helpful. So you all are working in an industry that is one of the most highly regulated industries that exist in the United States. And I work with clients who have a lot of regulations that they deal with. I have a significant number of clients that are healthcare clients, that work in the pharmaceutical industry, that work in aviation, that work in sales involving environmental products, highly regulated areas of work. But nobody comes up against as many regulations that touch as many different areas as a higher educational institution does. So you all have so many different roles and so many different things that you have to do and be aware of. And all of these categories have their own sets of rules, both at the federal and state level, that require different areas of compliance for you. So the employer hat, where you have to be on top of all the employment laws that change at the state level, at the federal level, all the things that you need to do. So you're an employer just like any private employer is. You're a nonprofit organization, that 501c3 status, which restricts what you can do with the funds that you take in. You receive federal funds. Those come with a scary amount of compliance obligations when you receive them. You receive state funds. Less scary, becoming a little bit more scary, what you have to do when you receive state funds and the things you have to commit to. You're also fundraising with private donors, which means that you are out actually making representations to private citizens. You have to be really careful about what you say to them before they send you money. So there's an entire category of compliance there that comes with that. You are a sales and marketer. You are selling and marketing your institution to students. This is becoming a huge area of enforcement. What do you say and represent when you're marketing your university? You're a landlord if you have residential students on campus. You actually do educate, despite, right? Like, surprisingly, with all of this behind you, you actually do provide an education, which comes with a whole host of obligations in how you treat student records. You are a lobbyist. Anytime that you are out advocating for your institution or advocating for a policy change that will positively impact your institution, or you've gotten wind of some piece of legislation or a bill, or there's some, like the Virginia Consumer Data Privacy Act, brand new Privacy Act that was out there. I would bet that there were some higher education institutions that were lobbying heavily for an exemption, which appeared in that act. Top of all that, you are, in fact, a city manager. So you have to worry about construction and zoning. You have to worry about environmental regulations. You have to worry about the police, security, safety obligations on campus. Those services. I mean, you guys have to deal with HIPAA and the privacy requirements for holding those records. You have to manage property. That includes understanding and managing your real estate portfolio and everything that goes into that, which the law is changing about, using LLCs and disclosing the beneficial owner of your LLC that might be holding your real estate property. You have to deal with traffic control, parking, public transit, private transit, shuttle service. And all of these different things are competing for your attention on a compliance background. So you've got to worry about discrimination. That's your Title VI, your age, disability discrimination that's unique to you in the higher educational institution environment. You have your finance, your tax, your 501c3, Title IX, and sexual misconduct. We're going to talk a little bit about an example of what that looks like for you and all of the areas of weakness that are there now. Clery Act, safety and security. What are you doing about reporting your data out? Your FERPA requirements, which, by the way, I mean, you've got some butting of heads coming up with some state agencies that want to do investigations and they want records or maybe issuing you subpoenas, which you actually have to comply with FERPA and give notice. Even in the face of a court order, you have to give them notice, students, that their records are going to be released potentially. And what is the intersection between your FERPA obligations and a sexual assault case that ends up being prosecuted by law enforcement officers? Conflicts of interest and conflicts of commitment. I do want to spend a little bit of time talking about what that is and how that impacts you. I think that, you know, I don't know if there was a low number of people that reported that because you feel really confident about your policies and the enforcement of them. But I will say it's probably one of your larger risk areas for your 501c tax compliance. And let me explain how that works. You are finding yourselves, we are all finding ourselves in a much more open, much more visible era where everybody's position on politics and political issues and policy issues is out there for everyone to see. And they're also much more engaged with organizations that engage in that kind of activity. So take an example, right, where you've got an employee who is using university resources, computer, university time, where you're paying them a salary, and they are perhaps using those resources that time, maybe an assistant to help them out, to actually actively work on campaign volunteer activities from that seat. Now, what happens if that employee in that seat doing all of that work, what if their manager finds out that that's what they're doing and they said, well, you know what, I like that candidate too. Completely fine. I want you to do whatever you need to help that candidate get elected. Let's take it one step further. Let's say that this person is so passionate about this political candidate for office. They've decided that they're going to open a business on the side where they're going to do some sort of support, right? Maybe it's a digital marketing campaign. Maybe they're going to reach out to students at the university and pay them to send peer-to-peer text messages on behalf of a potential candidate for office. Now you have an employee who has this conflict of commitment that has a resource of students that are more than happy to sit on their bed at your school and text people for 10 cents a text. And they have appropriated multiple resources of your university to the benefit of a specific candidate for political office. So now you can see how a conflict of commitment, a conflict in the commitment to the mission and to using the resources at your university to support that mission, potentially a conflict of interest because they've got a divided interest, or they might even have a financial interest if they've decided they're not just going to volunteer for that activity, they're going to do it for money. And they may be using the resources, whether it's students, access to student data, access to the physical resources of the university, and they're using it for an explicitly prohibited purpose under 501c3 regulations. And so this is one of those things, a conflict of interest and a conflict of commitment is usually a policy that appears in your manual that you have your employees sign off on. But it's not really a big area of oversight and enforcement. And it's not an area that you're looking into or that you've got a process necessarily. I don't find many institutions with a process for addressing violations of their conflict of interest policy, even though it can pretty quickly escalate for the wrong person who's just misusing resources into a potential threat to your 501c3 status. And really all that you have to have to bring this to the attention of anybody is somebody in the office who knows what's happening that likes the other candidate. And then they make a complaint. So again, these are all things that, like, sometimes they look like they're completely separate. They can have a substantial amount of overlap. Governance and fidelity to policy. And I'm going to talk much more about this. You can have the best policies in the world. They could be perfect. But if you are not ensuring that they're being followed, that they're being trained on, and that the governance structure supports their enforcement, they're not really worth very much. In fact, they're probably the best evidence against you in litigation or in an enforcement action, which is not to say don't have policies. Don't walk out of here and say, you know, Erin said it's just better if we don't have any policies at all. That's not what I said. Have policies, you need to enforce them. We're going to talk more about that. And then statistics and data reporting. Seems pretty innocuous, but actually that's probably the thing that's getting most of the attention for criminal enforcement. How do you report out your statistics? How do you report out your data? How do you take your statistics and data and turn it into marketing representations you're making to prospective students? How do you take your statistics and data and report it back to the agencies in a couple of these areas above? What are you doing to maintain that? What are you doing to make sure that your statistics and data is being accurately reported? So this is all so much more important because we're really in a different type of era. We are facing a huge uptick in lawsuits for areas and prosecuting cases that wouldn't normally get this much attention, but it's because the internet age has increased access. So somebody sitting in Ohio, for instance, might be able to go online and Google search their situation and a lawsuit. Somebody sued an institution over what happened to them over in Virginia, and they're able to find that. And so they can take that. So maybe before you had people who just didn't think maybe they had a claim or anything to pursue. Now they've got easy access to this on the internet. And so you also have this public demand and public attention for information about claims. And lawsuits can sometimes get immediate response and attention in a way that they couldn't before. So before you had the internet, a lawsuit got filed in a court. The only person sitting at the courthouse looking at new lawsuits is a guy on the court beat. That's it. It's like the one reporter from the paper that does this. Everything's online now. Everybody issues a press release when they file something. This is all newsworthy. And it frankly doesn't matter whether it's meritorious. You get the same amount of attention. When you file a complaint, nobody's responding back. It gets the press attention. Your allegations sound, all the press does, all the media does is say, these are merely allegations. That's it. And then they list everything paraded out. And so there is a benefit to filing a lawsuit, even if the claims are not ultimately meritorious. There's a hit, a public attention bump, an added point of pressure. Maybe they'll settle anyway because they want the negative attention to go away. And then you have social justice movements that have affected the entire country, have really hit sort of a pressure point on campuses. There's increased scrutiny and attention on campus policies, the enforcement of campus policies, the transparency about the enforcement of campus policies, and what exactly you're doing and whether you're doing it consistently. Then you have employees, staff, and students all over social media, sometimes commenting on said social justice movements. I mean, I can't even tell you how many stories I've come across in the last 6 months about a professor at University X who made a comment about why, and now there's a public outcry for their firing, and just there's all kinds of different pressures that are coming to bear on institutions. So you have this increased pressure to respond in some way, shape, or form. And so that's kind of the question here. We talk about compliance and all of these pressures. What do you do when you need to respond? So when you're responding, understand you've got some new laws here that you have to make sure that your response and the way that you move forward, these are some new restrictions. So in Virginia has a whistleblower protection. I'm sure Todd has talked to you before about it. I know you guys were virtual last year. That went into effect in July of 2020. It's pretty significant. It's pretty broad-based protection for somebody who comes forward with claims against retaliatory action for employment. One of the things that we have seen increase a little bit is that somebody who is under investigation for misconduct themselves, who is savvy and knows about this, will make an allegation to thwart any enforcement action you're about to take on them. So if they've engaged in misconduct, they know you're looking at them, they will kind of proactively take this step, make a complaint. That way they can invoke whistleblower protection or sue you if you go ahead with any sort of disciplinary action against them. And then I'm assuming everybody, I don't think you can be on a campus and not be aware of the Title IX procedural overhaul. And then the additional guidance that came out. So you've got sort of 2 rounds of things you need to comply with that all came out in the last 2 years, which had a dramatic impact on how that's investigated. New applications of existing laws. So just straw poll for my people who are here. How many people worry about antitrust compliance? You should probably start worrying a little bit about antitrust compliance. So something to watch. This is a really recent thing. This is not higher education, but it does go to the fact that I listed all of those different hats you guys wear. And when you, as universities, are acting as purchasers of books, let's say, or any goods, well, let's say books, and you contract with a specific vendor, and then together you set one price, or you restrict where the purchase of the book can be. The US Department of Justice has gotten much more aggressive in criminal enforcement of antitrust, right? The other thing is that if you set book prices with a vendor, or you're in a, sort of an association of other institutions that buys books together and you all agree this is just going to be the price, you have to be very, very concerned about restricting where a student can purchase something and setting a strict price that doesn't allow them to shop around, or that requires sole sourcing. And its antitrust is that you are essentially controlling this little mini market. You're creating this tiny microcosm market, and you're controlling all of the competition within it, and you're controlling all of the purchases within it. And so that is something that the Department of Justice and the Department of Education have been really clear. You're not allowed to go down that path as an institution. You don't have special rules that allow you to do that. You have to be very careful about creating little mini monopolies where you're not allowing competition and shopping outside the market that you create. Another area that they have gotten more robust in enforcement when it comes to higher educational institutions is in financial aid awards. So there have been institutions that have agreements that they're going to set financial aid awards at a certain level and not make individualized determinations at each university for each student. And those sorts of agreements can come under, and antitrust laws in the United States have a lot, like it's this big sliding scale of enforcement options. So as is much of what I'm going to talk about today, there are fines, there's civil enforcement, there's orders and agreements and probation status, all kinds of things, but all the way up to criminal enforcement against individuals. And that's why you have this note. I mean, why else would you guys care about poultry executives? Well, here's why you should care. The Department of Justice is pursuing a novel theory of prosecution under the antitrust laws, and they're going after individual CEOs of poultry companies, the largest poultry companies in the country, and they are prosecuting them for criminal antitrust violations because they said that they set the prices, like they set the wholesale prices for the market. This is another kind of related area. I'm going to jump down to, we're going to skip Temple. We'll talk about Temple in a second, but we're going to skip down to no poach agreements. So again, it's anti-competitive activity, but the Department of Justice has gone really hard after not the financial sector, the tech sector. So you had a couple of big tech companies like Google, and Microsoft and a couple of other companies who had agreed not to steal each other's employees. They're high-level employees. They had agreed, we're not going to go steal them from you. We don't want them jumping around. We had some rough agreements about what was the appropriate salary and benefit package to offer people at certain levels, and they're suing them because it is suppressing the labor market. So that you have these big tech companies who are colluding together to suppress the labor market. And that's a civil enforcement action that the Department of Justice took. That's really easy for you to slip into if you have a collection of institutions. I'm from Richmond. We have a ton of colleges and universities in Richmond. So if everybody around there said, well, look, we have a closed market, we really don't want to be stealing from each other, have people just hopping from one place to another. Let's just all agree that at a certain level, we're not going to steal each other's employees. That could get the attention of the Department of Justice, and it certainly would give one of those employees the ability to sue you for anti-competitive practices. So you have to be very careful about some of these no poach agreements. They come up most often in your higher value, more specialized positions. Criminal enforcement actions. Does everybody know about Temple University and what happened there? Nodding or shaking head no. Okay, there are some no's. Oh, okay, well, this is where university officials can actually get criminally prosecuted and put in prison. This is about data reporting. So this was at Temple University School of Business. And what they were doing was manipulating the algorithm on admissions applications. So the definition about, so university has to have a definition about what it considers to be an application for admission. You have some leeway about how you're allowed to define that, but it has to be sort of like gut level, gut check, thumbs up, sounds good. So let's see that you have, what do you consider to be an actual completed application for admissions versus like kind of sort of completed versus just some sort of statement of interest or something. And so if you can imagine, and this is about US News and World Report rankings for Temple University School of Business. And so what they were doing was manipulating the algorithm in such a way that they were considering somebody filling out, and I'm just going to give an example. Let's say your institution had like an interest form, and they just, a prospective high school student goes onto your website, they fill it out so that they get materials and information, give a little bit of information. That's an application for admissions, let's say. Well, that makes you look very selective, right? As opposed to only counting a completed actual formal submission of an application. And so that's kind of a huge range on the scale. And where you fall on that scale is the ability to manipulate how selective your university looks. And that selectivity, or one of the other ways that has come under investigation and scrutiny from the Department of Justice. So this was a US Department of Justice criminal prosecution and conviction very recently. I want to say within the last 8 months, I think it was a fall criminal trial that they got a guilty verdict out of. So that's a criminal conviction for the head of the School of Business at Temple University, who knew about the manipulation of the number, and it ended up making false representations about the selectivity of the school to bump them up in the rankings. And that was a misrepresentation to the students who relied on that in order to choose that university over others. There's another common area, which is how many people are employed, like out of your graduating classes, right? How many of your students actually get jobs after? How many are employed in their field of interest? Well, what do we consider employed? Is it part-time? Is it full-time? Do they have to be paid? What if we create unpaid internships for them or paid internships for them so they look employed? Is that the same as really getting a job competitively in the market? And is it a good representation of how competitive your program is and how highly valued your program is among employers? So there's a lot of and consider this from like a federal prosecutor's perspective on this is very simple. Your university and whoever was in charge of making this decision made a false statement to an outside private business that ranks universities or programs at colleges on a scale, and students relied on your false representations and made a decision to go there and gave you money. Or the federal government gave you federal loan money, which is another federal program fraud potential prosecution. So this is the kind of thing that should be making universities and institutions nervous about whether you have somebody in the room making these decisions, deciding what is going to be the definition for admissions application, deciding what is going to be the statistic that you use, that you report out when you're getting ranked, and making sure that that is intellectually honest and you have the ability to back that up. If an enforcement agency came and asked you how you got there. How about Varsity Blues? How many people know about the Varsity Blues case? That was in the news a whole bunch more, right? Even has a fun name. Temple University didn't even have a good operation name. It's really disappointing. Varsity Blues had this great operation name. Aunt Becky got prosecuted, which was terrible. So that is prosecuting under a theory of federal program fraud, which is a little interesting and goes a little bit like this. If you receive federal funds, which I'm assuming almost all of you do, in some way, shape, or form, even federal student loans funds from students enrolled at your university, then you have to be honest and not make any false statements in connection with that program. So Varsity Blues is a lot easier to see, right? Like people were bribing people for spots at a university and lying overtly about somebody's, like the number of girls that were rowing was amazing. They were really smart. They were photoshopping them onto like boats and everything. You have to admire the dedication to the fraud there. But that is another area where understand what this means. There is a public perception of corruption in the admissions process for some of these institutions that's going to lead to public pressure to make sure there's a lot of oversight. This sort of took the shine off. They want to know what is going on in your admissions process. It will increase the need to be a lot more transparent about these things. So compliance for all of these areas is huge. And there's a lot of different paths towards compliance. That means there's a lot of different opportunities for you to have a weak spot in that compliance area that could bring you under an enforcement action. So all of you have Title IX obligations. So just a case study to walk you through what this looks like and all of the different points where you have to make sure that you have a process that addresses everything you need to address in the way that you need to address it. So student A alleges a sexual assault on campus committed by student B. Very straightforward. We're not even going to get into a conversation about like what was kind of sort of off campus, but you guys decided that you're going to cover it. No, just cleanly on campus, actual sexual assault allegation. You as an institution, you receive a complaint, you conduct an investigation pursuant to your Title IX procedures, the investigation results in a recommendation of action, and the recommendation's followed. It seems super simple, right? As long as you do these things, you've got procedures, you had a process for taking in the complaint. This should be the thing that keeps you insulated. And the reality is that there's a ton of weaknesses in this process that can be probed by an enforcement agency like the US Department of Education or private litigation where one of the two parties, student A or student B, ends up suing you. So the key compliance challenges here, policies. So it comes into 4 different groups. The first one is policies. And the questions you have to ask yourself, do you have policies that cover every step in the process? And I mean that you should be sitting down. And this, by the way, we're talking about sexual assault and Title IX compliance. You can take this and lift it into any of those areas of compliance that I talked about before. So, do you have policies that cover every step of the process? You should be sitting down and walking through what it would look like when you get an allegation of sexual assault, what it would look like when you get an allegation of misconduct by a university employee. And map out your steps. What would we do? What would we do? What would we do? You should make sure that your policy covers every step in the process. Then, when you're looking at Title IX, it's really important to know when was it drafted. Because if your Title IX policy was drafted in 2001, you have a problem. So it's got to be drafted, yes, and in compliance when it's drafted. But then it also has to be reviewed and revised. For Title IX, it needed to be revised after August 2020, and then again after June 2021. Because guidance from the administration came out that made those 2 dates critical to make sure that your policies were in compliance. And then make sure you can draft them, but it has to be implemented. So this is the first area you have to take. The first step is we've got to have policies for compliance on all of these issues. You have to train on them. And you have to know when your last training was. You should be documenting who attended it, who took it, how long it was, how the training was delivered and by whom. How experienced is your Title IX investigator? So you've got your sexual assault. How experienced is your investigator that's conducting this investigation? Is it the first one they've ever did? They should have a friend. You don't ever want to give someone brand new something this complicated. Does your staff and your review panel know how to remain neutral? And the most important thing, do they know how to appear neutral the entire time? Because the appearance of being partial to student A or student B is probably one of the biggest risk factors you have in whether you're going to get sued or whether you're going to have the Department of Education coming back behind you to see what was your enforcement like. So the next category is implementation. So what supportive services did you offer the complainant? What supportive services did you offer the respondent? Because in a Title IX investigation, you have to offer supportive services to both Did you provide due process? That's massive, right? I mean, I will not gloss over how complicated and difficult this is. After the August 2020 revision to Title IX, you as institutions are responsible for pretty much holding many criminal trials inside of your institutional policies and procedures. You have to have attorneys there, you have to have due process protections, you have to provide notice, that's part of due process. You have to provide everyone a meaningful opportunity to be heard. You have to meet all of your deadlines. You have to give them a sufficient amount of time to see the evidence and be able to respond to it. They have to be able to probe the evidence and question witnesses. Did you properly conduct all of those things? Because this is a huge area of risk for you moving forward. And your policies and your procedures have to be extremely precise in how this is meant to be implemented. And then nowadays, this big thing, perception. Does the process feel fair to your campus community? Because if it doesn't matter if you did the rest of it. You still would potentially face an investigation from an enforcement agency or private litigation from either student A or student B, because they felt like you guys are an easy target because you don't have a good record in the past of enforcing this policy or adhering to this policy. Have you been transparent? What does transparent look like when we're talking about which different compliance policy? And so you're constantly balancing this act, and so many of you work in finance, and so I know one of the primary concerns that you have to have is, it would be really easy for me to tell you the best response is for you to hire an army of people about compliance. This is all they do. They eat, sleep, breathe compliance all day long. But you have to be fiscally responsible, especially for smaller institutions. It's impossible. You've got one person wearing multiple hats because you have to. So these are absolutely, there is a balance to strike there when it comes to compliance. And I'll tell you what the minimum thing you need to do on this. Your policies have to be current, they have to be comprehensive, but they mean nothing if you don't do training consistently. And every time you have a policy update, you have to match that with a training on the policy update and document that. Because otherwise, this is just going to be a great exhibit for the plaintiff suing you in litigation. Transparency and trust. You need to make sure your community on your campus feels like they can trust you and that you're being transparent about your policies and their enforcement, but you also have massive privacy and confidentiality responsibilities for all of these students, for your staff and your employees that might come under these policies. And so you have to figure out, how do we strike that balance of making sure we're transparent about what our policy is, when we do our trainings, how we enforce it, without divulging in a particular instance information that could identify somebody that was a part of a particular enforcement action or investigation. So this is the minimum thing that you should know about the compliance areas. The institution has to know, one, all of its obligations. What are all of the unique obligations that apply to all of those different subject matters that we talked about before? And then what are the changes, both in just the compliance piece itself, like perhaps your reporting requirement is changing, the date of your reporting requirement is changing, or are there legal changes like there were with the revision of the Department of Education guidance about Title IX enforcement? So that's the institution at a minimum has to know what its obligations are. But then here's what you have to do then in response. You have to have a policy in place. Like if you call me and say, Erin, the Department of Education or the Department of Justice, they're calling us and they're concerned that we have an employee that was not properly reporting the statistical information that they were relying on for issuing financial aid awards. And one of my first questions is going to be, okay, well, what was your policy about that? Because if you don't have one, my first line of defense, I can always explain, you can never get rid of all of your bad apples. As your attorney, though, that's what I want to be able to say to the Department of Education, to the Department of Justice, is, okay, but the policy was here, and the training what happened here, and this person took the training, and this was the oversight, and here was the person responsible for compliance, and they did their job, and they checked on doing their job, and we can't help when we have a bad apple, and here's the bad apple on a silver platter, and please do not do anything with our federal funding. You want me to be able to do that, but in order to be able to say those things to somebody who's looking over your shoulder, or in order to be able to arm your attorney to defend against a lawsuit from student A or student B who's suing you because you didn't do this the right way, you need to be able to hand them these things. So take your compliance matrix, the massive thing that it is, and map out who's responsible for this compliance across departments, and have them, the institution should have a matrix of what your compliance obligations are and who you have assigned to champion that, oversee it, keep up to breast with updates, and have a schedule for checking back in to say, hey, listen, this change just came, we probably need to change this policy, and then we'll need to push out new training on it. I've got the ball on that. It needs to be somebody who's a subject matter expert in that particular field. Obviously, you do not want your HR people drafting your tax compliance policies. That would be a disaster. So you also have to have somebody, again, it's great to have policies and training and compliance responsibilities, but where is the oversight to make sure that there is a fidelity to policies and procedures? There have to be consequences for failing to comply, have to. Because if you have policies, procedures, and training, and you update your policies and your procedures and your training, but your institution finds out about violations and non-compliance and does nothing, it's going to be almost impossible to defend. So you have to have somebody that's there to say, we have consequences, disciplinary actions that happen when we have non-compliance events. So someone inside your institution has to be the compliance champion, somebody. And it doesn't matter who that is. They can wear a lot of different hats. This can be a different person, but it's got to be somebody that's got their eye on all of this and is like, hey, we need to make sure we're doing this enforcement. We need to make sure we've got that we're following our procedures when an act of non-compliance or misconduct comes in. So this is another poll. Where does as you sit in your seats today, if you had to pick who you think at your institution, even if that's you, is your compliance champion, where do they sit? Or do you think you don't have one, or you really just don't have any idea? This is your poll. So number 2 and number 3 are my favorite answers because lawyers are nervous and jumpy people, and so they like for you to comply with the laws usually. And then when you have somebody that actually is, you have this hat and you have to say, you are the internal audit person, you are the compliance person, that's great too. Because sometimes inside counsel can have a bunch of things on their plate, but they're a great person to have as your champion. Finance, so much of this touches finance, and finance people are the compliance people, right? Like you have so many obligations, reporting responsibilities, professional certifications. It's why a lot of you are here. You have obligations and fiduciary responsibilities. These are great people to have wear this hat when you don't have inside counsel, when you don't have a specific compliant or audit person, because you already have a compliance brain. So that's great. But does that mean that your finance person is making sure that your Title IX policies are up to date, or is making sure that your anti-discrimination policies are up to date in your human resources department, or is making sure that people are filing conflicts of interest and conflicts of commitment, and making sure that there is an internal investigations process that allows for complaints and enforcement. So that's one issue, and human resources, a huge part of human resources is compliance. But the thing is, the compliance for human resources and compliance for finance, you guys approach up compliance in different ways. And you're not always going to have your eye on the ball of the compliance happening with someone else. And so where is the person that is in the office at your institution that has their eye on all of it, and make sure that there's a consistent process? And I'll talk about it in a second about investigations and enforcement, which is such a huge piece of what you do. Outside counsel is actually a great answer for some smaller institutions that don't have inside counsel or don't have somebody that sits in this specific compliant internal audit process. That does not mean that you need to call outside counsel up to constantly say, hey, we had this allegation. Well, I'll talk about that in a second. There's a lot that you can handle in-house, but it is good to take outside counsel's temperature twice a year. So you do kind of like biannual audits of your compliance obligations, changes to the law. Do you need to update any of your policies and procedures? And just all you do is you engage them for that. Survey our compliance obligations, check out our existing policies and procedures, give us your thumbs up that we're good, and do it again in 6 months. That's fine, especially for institutions that are smaller and don't have any of these people in-house that have the capacity to wear this hat. And then we don't have one. You should definitely get one. Hopefully that's the point of this for you guys. And I don't know, everybody who's sitting in here with some sort of, if you have a position that requires you to get continuing education credit to maintain whatever certification you have, you're considered a fiduciary. And so you should make sure, as that fiduciary role, you can at least identify who in your organization wears that hat for compliance, and is that compliance champion in your organization. Okay. Compliance means nothing if you're not enforcing it. If you don't have a mechanism for finding instances of non-compliance, you're not really doing compliance. So it's critical to it. Any federal agency will want to know whether you're enforcing your policies, whether you're following your procedures, and whether you're investigating actions of non-compliance. There has to be a method for doing an investigation, but there also has to be a reliable method for reporting allegations. And it's very, very, very protective for you. If you have these things in place, it's really an excellent defense. Even if you have a bad apple, you've got this defense for any of that enforcement action or litigation. It depends on the nature of the allegation. Sometimes you need an internal investigation, especially if it's smaller and it involves lower level staff. If you have allegations against the president of the university, you should not be doing an internal investigation, because whoever's doing it presumably reports to them, unless you have the really good structure of a specific audit person that gets to report to an audit committee of your board and bypasses all of the layers in between. And there's a way to set that structure up and have that done, but you cannot have somebody that reports to the person that they're investigating. That's a disaster. You do need outside counsel there. Okay, so every single investigation that you do into a compliance issue has to have the following things. There has to be a procedure for intake and initial assessment. So that means that you have to have a way of getting complaints into the right person and assessing them. You're going to get absolute nonsense. Of course you are. You're an employee who's going to be mad that, you know, their parking place, they think it's age discrimination because their parking place is like 3 spots down from the younger person. You're going to get nonsense. However, you have to have a way and a process and a procedure for dealing with nonsense and doing that initial assessment. You have to make sure you assign this to the right investigator. So I'm going to talk a little bit more about this too. Who is your right investigator? It's going to depend on your compliance area. You have to have a procedure and a timeline for conducting your investigation, a process for gathering and preserving evidence. And it should be explicitly spelled out how you do that. Because what would be a real disaster is for you to have all these great procedures and you have an investigation into an act of non-compliance, and all you have is the person looks at the complaint and they're like, I don't know, it doesn't seem real. I think it's fine. I asked this person, we had a 2-minute conversation. No, it can't be a sham investigation. The feds don't like sham investigations. It has to be a real one. You have to take steps if there's evidence, you need to gather evidence. So that might be emails, right? You've got employee misconduct, an allegation of non-compliance. You're going to want to look at their emails. You're going to want to look at the documents. You're going to want to talk to people and interview them. That's all preserving and gathering evidence. You have to maintain confidentiality, because disclosing something like this when it's a half-baked allegation can cause a whole other set of issues. So your process for doing investigations has to have confidentiality kind of baked into every stage of it. And then you have to have a process for taking action or not recommending action. There has to be something written down that says, hey, these are the factors we're going to use to make this decision. And then you have to have something to enforce non-compliance. You have to do something. There has to be some consequence for that. So a really bad example would be for you to have like a sustained complaint against an employee for Title IX sexual harassment. Decide that you're going to suspend them for 3 days, and then a week later, give them a promotion and a pay raise. That's a real situation that has happened at an institution. That is an absolute disaster for your attorney to try to defend. That's not real. I mean, it looked on paper like it was real unless you flipped to the next page in that guy's personnel file. And then it suddenly didn't look like it was a real enforcement for non-compliance. So how you receive reports. This is probably the most important thing you can do to increase the campus community's feelings, their perception about your culture for compliance and enforcement. It's how you receive reports. So consider what the requirements, all of these different compliance, Title IX, just you've got to have a proper way for reporting it. You have to follow Title IX procedures. Title VI, you've got a way of reporting it. You've got to follow that. Some of these other areas that are a little bit more amorphous, you need to have a default position for allegations that come in, and consider what the requirements would be. What do you want the reporting mechanism to look like? Consider these 2 points here, which is anonymous reporting of complaints. Will you get nonsense? Yes, of course you will. Will you get good stuff? Yes, absolutely you will. Will it dramatically increase the campus's trust? And this is when I say anonymity, like it's a contract with a hotline that it's a service provided. You go and put an online report in, and it ensures anonymity. You have a closed group of people that receive the reports and are charged with sort of ferrying them to the right place and initiating an investigation. Also consider a process for direct reporting to an audit committee for your board in order to handle the allegations from their inception about members of senior leadership at your university, because that is probably the single most thing that damages the perception and the culture of compliance, the perception of the culture of compliance at your university, is when you don't have that way to bypass members of senior leadership if you have allegations. Okay, so initial assessment. What do? You want to make sure that there's a process for determining whether an investigation is necessary, right? So the age discrimination, because the parking space is 3 spots away, probably doesn't need a lot of investigation, but set out what the scope is going to be. This should all be in your procedures. The third one sounds weird, like, right, like, why do I need to name the investigation? And it is not just because I'm a federal prosecutor that really loved naming law enforcement operations, although it's true, and I did. But take a page from the book of the FBI. The FBI, because they occasionally agents, as a federal prosecutor, I can tell you sometimes they would name operations unhelpful things if you had to talk about them later in court. It could just not be the most best name for an investigation. So they randomized the names. They would pick like two, they have like a random name generator. You can get 2 words, that's what it was. Sometimes it's silly, it's fine, it's innocuous. Anybody asked you about it, randomly generated the name. Here's what not to name the investigation when an allegation first comes in. So it matters what you call it forever if this comes to pass to be anything. So if when it comes in you say Title IX sexual assault before you've done any investigation, you've just called it a sexual assault, you've just called it Title IX, you will be answering questions about why you made the choice to call it that forever and ever and ever. So have a policy for, you have a standard innocuous way to refer to that allegation. I love numbers. Numbers are fantastic. They say nothing, nobody gets stressed about them, they are numbers. Be careful in your communications about how you refer to it. And then you need to have a process in your initial assessment procedures for determining what are your immediate steps that are prompt, that are reasonable, and that are adequate. What are the first steps that you can do? How quickly do you need to respond? How quickly do you need to start to gather evidence? What are your initial things that are reasonable? And it's going to depend a lot on your compliance area, right? When we're talking about Title IX, if you have an allegation of a very violent sexual assault, what is reasonable and adequate and prompt is going to look a lot different than the parking spot allegation later, right? So you have to have some sort of matrix for determining what are the initial responses. When you have financial misconduct allegations against an employee, you also have to think, okay, what is reasonable and prompt and adequate here? We may need to remove this person's access to the finances of the university. Okay, choosing the right investigator. You shouldn't have HR investigating a Title IX complaint. You shouldn't have a finance person investigating a Title VI discrimination complaint. You shouldn't have your Title IX coordinator covering investigations of financial misfeasance. You shouldn't have, you get the picture. They have to know. So it's likely you may not have just one investigator. The right person is going to depend on the compliance area that you're looking at. You need somebody who is a good communicator, that knows how to talk to people, that can actually have a conversation in a situation like this without sitting down, having the questions typed out in front of them, and that their MO is to read from the paper, then look, and then completely stop making eye contact and look down and write. Because if I was doing this the entire presentation, so many more of you would be sleeping than are already. So the temperament of the person, they have to be calm and measured. People can be, that their interview may be really animated. You may have to interview the person the allegations have been made against. That investigator needs to be able to handle that with grace and be calm and measured. That can get pretty animated and heated. Also have to be courteous. And then most importantly, they have to be credible. And that is credible, it's the perception that they're credible. And this is where you can't have the vice president of the university investigating the president of the university. You just can't. That is not going to be a credible person to lead that investigation to anybody. That is where you have to kind of make your assessment. Do we need to go with somebody outside to engage them just to do this investigation because of who the allegations are against? Do we need to do something like that because of the seriousness of the allegations? Do we need an outside party? Is this going to be something that someone later is going to say we couldn't or should not have investigated this ourselves? Okay, so the process for your investigation needs to be set out in your timeline. It needs to be firm. You need to set forth, what do you do when you conduct an interview? You cannot promise confidentiality. You often are not going to be able to keep that promise. You do need to make reassurances that there's not going to be retaliation for making a complaint. The most important thing in your investigation process, this is not a typo. It's on here twice for a reason. Document. You have got to write a report. You could do the most amazing investigation. It could be so neutral and fantastic and thorough when you've peeled back all the layers of the onion and you've gotten to the real truth. It's amazing, and you keep it all in your head and you don't document it. And when it comes up later in an enforcement action or someone files a lawsuit, as your attorney, I've got nothing to give anybody about your fantastic investigation. I have nothing to report them to about credibility determinations that you made. And that is something that's really important. You're interviewing people. You should be reporting this in some way. There has to be some documentation of at least the steps that you took. And then you have to actually make credibility assessments if you're going to interview people. You have to find it credible or not credible. It's what supports everything that you did after. You have to be documenting that. Then you have to figure out what are going to be your triggers for external reportings, depending on the compliance area. What do you need to do to report this out potentially to an agency because you have obligations? Remedial action or response. You must be consistent about that, and also document. Figure out what you're going to communicate to your employees if you can. If it's an employee situation, can you share something to at least know that it's been, because sometimes maybe you can't say how it's been resolved, but you might be able to tell people this very public allegation, we investigated thoroughly and we resolved it. That's it. That's not actually breaking anybody's confidentiality or sharing any private information. And then following up, huge mistake not to follow up. If you have an identified complainant, you do a whole investigation. Let's take sexual harassment because it's super easy to illustrate this point. They have somebody who is making sexual comments to them. They felt unsafe, they didn't like the environment. You address it, you do an investigation, take disciplinary action. Go back a month later and ask your complainant whether anything's better. Because if you follow up, then you document it and they say, yeah, actually, thank you. Things are great. If that person decides to file a lawsuit later, you have documented that they told you things were a lot better. If you go back and they're like, no, nothing has changed, well, then you know that you have more work to do. You have to make sure that you follow up and document your follow-ups. Common mistakes that will draw outside attention. Mischaracterizing the complaint, not following up, failing to fully address all the issues, right? So if you look at it, you kind of shrug your shoulders, and you write down that you looked at it and it seems like it's not really a big deal. That's not enough. You didn't fully address the issues. Poor documentation, waiving your attorney-client privilege. Don't do that. If you consult with an attorney about how to conduct the investigation, don't share attorney advice. Don't use attorney advice as something that you're going to say in litigation and say, well, I followed the advice of the attorney, and that's what the attorney told us that we had to fire this person. The attorney told us we didn't have to fire this person. You have just waived attorney-client privilege. You can seek advice from an attorney, but what you have to do is say, I received advice from my attorney based on that and all the other information that I gathered. We made this decision independently. That's the way that you protect your privilege. Don't retaliate against people making complaints. It's a whole separate thing. And depending on what bucket we're falling into, that can be its own federal criminal enforcement action. Retaliation is called witness tampering or witness intimidation. You really don't want to do that if there is a federal investigation. It's 10 years in federal prison and they take it super seriously. failing to communicate the outcome when you can, not being consistent in your enforcement of policies. All right, this is our last poll before I leave it for questions. It's the redo poll. I'm just interested to see whether it changes based on the conversation that we had. Oh, see, some more people. Conflict of interest and conflict of commitment. Great. And fidelity to policy. And yes, of course, I've talked about Title IX a bunch, so you guys are probably all freaked out about that, right? You know, well. So thank you. I do appreciate that. And I hope that, you know, I know that this was a massive overview. I didn't do a deep dive of one issue. You guys have really hard jobs, and I'm sorry for that, but I hope at least this has spurred you to maybe take a look at what you have in your books and see whether there's room for some improvement. So we've got like 2 minutes. Are there any questions? Go ahead. Yeah.
What's the federal prosecutor opinion of the definition of academic freedom in the classroom? Things that happen in my classroom are mine to do, even though they may violate some policy.
Yeah, so I think that when you're teaching, right? So if you're teaching something, and I'm going to assume that when you say academic freedom in your classroom, you're talking about teaching something that technically could be a violation of policy. Is that right? Am I right about that?
Well, let's say I used an example that was offensive under Title IX to someone or multiple someones. And so then is that my opinion? Being a compliance person, that's Title IX violation. That you
right.
You follow the investigative process. How do you counteract the academic freedom that, you know, I used this example 25 years ago. Why is it not relevant today?
Yes, that puts a finer point on it. So there isn't academic freedom to every comment, and Title IX is one of those areas where you can create an environment that feels hostile. So think of it like a hostile work environment type of claim. You can create an environment that feels hostile and is sexually charged by the nature of the comments that you're making. And you would have to make an example, you would have to make the case that this example, this was absolutely necessary to be able to talk about this in this way in order for me to be able to rely on it. So the actions have to be reasonable. And I did this 25 years ago isn't really a reasonable response. Now, when I was a federal prosecutor, I taught a class at JMU as an adjunct professor. And we talked about a lot of sexually explicit things in that class, but it's because it was about sex trafficking. So again, right, it's got to be about context, and your comments have to be appropriate. And also, my mind is going a million terrible places for whatever example he used that could generate a Title IX complaint. But it has to be, there's no such thing as the freedom to harass another person or the freedom to create an environment, whether it's teaching or work or otherwise, where you are in a position of authority or power over another person, or they're in a situation where this is not very unlike a workplace, where in a classroom, a student is taking credit for a class, they can't just leave. If attendance is taken, they can't just leave. And so they're this captive audience. And so when you're in a position of power over that captive audience, you have to be responsible in exercising that. And academic freedom is not an excuse to create an environment that would be hostile and sexually charged. Does that make sense? I saw you taking notes, so hopefully that was helpful. Any other questions? No, nobody else has anything as good as that, right? So you can't. Everybody's thinking about what was the example that he used.
So my question is, in a data breach
Yes,
where FERPA information is revealed,
okay.
is there a compliance standard that the Department of Education is requiring that, if not followed, could get an institution into trouble?
That's a great question, and I would have to do some research about it. However, the FERPA requirements are so strong about notice. And my first gut reaction without doing any research would be to suggest to you that if you had a HIPAA breach, for instance, or something I do know about, you have an obligation to notify about the breach as long as the records did fall into FERPA. So if you know that it does, your compliance obligations, because it's sort of, even without putting my finger directly on it, I would tell you that it would be inherent in your duty to preserve the privacy of the records. If you've had a breach, that you do have to provide notice, because essentially you've got records that have gotten out. If you have to provide notice, even when a state law enforcement officer issues you a subpoena to turn those records over, you have to actually provide notice to students before you can release them to be in compliance with FERPA. Then when you have an unauthorized data breach, you have to do the same thing. That would be my gut reaction, but I'd have to be able, that would be something where you would need an attorney to go put a finer point on exactly what requires you to do that. Anybody else? Well, thank you guys. I really appreciate you hanging in, especially in the afternoon slump, especially if you didn't eat any of the candy or candied bacon. My contact information is up there. If you think that either I or one of my incredibly talented partners, who is super subject matter experts and sir on both, on all kinds of privacy breaches and FERPA requirements for educational institutions, just reach out. Thank you guys so much.